Welcome, everyone. We're going to just give it a minute to let everybody funnel in. People are still coming in, so whenever I kind of see it plateau, we'll get started. Okay, a couple more stragglers. All right, let's go ahead and get started. Hi, everyone. Thank you for joining today's webinar presentation, Garbage In, Garbage Out, the Need for Comprehensive and Clean Data for Patent Research. I am Leah Wilhelm, Senior Manager of Demand Gen at LexisNexis Intellectual Property Solutions, and we have a really informative webinar planned for you today. But first, I would like to cover a few things before we get started. This webinar is being recorded, and you will receive a link to access it in a follow-up email. You can download the handout from the chat section. You should see it now. If you have questions during the presentation, please use the question section. If you have any audio visual problems during this webinar, please let us know using the same question tool, and we will do our best to resolve them. We will answer as many questions as we can at the end, and once the webinar is over, you'll be prompted to complete a short survey where we welcome your feedback on this topic. All right, next slide. This event is approved for 60 minutes of CLE credit. The type of credit requested is ethics. The type of credit allowed is determined by the state governing MCLE board, and attendees will need to validate participation using the 2 codes that will be provided during today's presentation. Be sure to write these down or take a screenshot of the slides when they come. Codes will be provided both visually and verbally. Next slide, please. Within 5 business days, you will receive an email from LexisNexis University that prompts you to log in to your LNU account to validate your participation and to complete a brief survey. Once you validate your participation by entering the 2 participant codes, you will receive your certificate via email. You always have the option to download a copy from your LNU account. If state approval is pending or needs to be processed, you will receive an email providing that status. Now, I will turn it over to today's presenter, David Dillenschneider.
Thank you, Leah, and welcome everybody. Hope you're going to enjoy this presentation today. As Leah just mentioned, my name is David Dillenschneider. I'm a client relations consultant for LexisNexis. And as we get started with this presentation, I'm actually going to kind of turn off my video because I want you to focus on actually what I'm showing you up here on the screen here right now. You can kind of get a sense of what this is just by looking at the screen, but I want you to understand that this is an advertisement for this thing called a manure spreader. It was manufactured, you'll see it up there at the top, by the New Idea Spreader Company, headquartered in Coldwater, Ohio. You see that at the upper right. Now, by the way, if you don't know where Coldwater, Ohio it is, it's basically kind of northwest Ohio, kind of between Dayton and Toledo. But anyway, I wanted to show you this because I also wanted to show you this next picture, which is a photograph of Joseph Oppenheim. Now, he was the founder of the New Idea Spreader Company and also the inventor of the manure spreader itself. So a little bit of background about him. He invented the manure spreader and founded the company after, when he was working as a teacher, he realized that during planting season, during the school year, his students didn't come to school because they were out in the fields helping kind of with the planting. So he kind of had this eureka moment which inspired his invention of the manure spreader. And you can actually see the patent up here on the screen right now. This is an image of the original patent for the manure spreader that Joseph Oppenheim received way back in 1900. In fact, you'll see his name up there at the top, Joseph Oppenheim, as well as Maria Stein, Ohio, which is very, very close to Coldwater, Ohio. And believe it or not, Joseph Oppenheim actually has his own Wikipedia page, which notes that he invented the modern widespread manure spreader. I kind of underline that. Now, he filed the patent application back in February 17, 1900, when he was about 41 years old or so. And it was granted on May 1st, 1900, so less than 3 months later. So think about that speedy timeline when you think about the patent work that you do. Now, unfortunately, he did pass away. You'll see there at the top of the Wikipedia page on November 24th, 1901, just about maybe 18 months or so after the patent was granted. Now, I want to take you back to that original patent for Joseph Oppenheim for the manure spreader, okay? So there's the name Joseph Oppenheim up there at the top. I've kind of highlighted it for you. And I've also got the name of the patent, or the device, I guess you'd call it, the manure spreader, distributor, and spreader. Then you've got some initial language of the specification, the opening language, to all whom it may concern, unquote. And then, in the body of the patent itself is a word like distributors, et cetera. All right. So why am I showing you this, right? This information about Joseph Oppenheim, and specifically this patent that he received for the manure spreader. Well, I'm doing this because I want to really highlight how some platforms out there misdigitize patents and applications. So for instance, look at this one. Now, some of the misdigitizations are kind of fairly minor, like in his name, you've got that random apostrophe kind of inserted in there. Or you've got the misspelling of the word distributors in the body of the patent. But some of the other misdigitizations are kind of way off. For instance, it's a bit difficult to determine the actual name of the invention when you look at it at this platform. And the initial language in the specification is kind of almost unreadable. And then finally, the quote, to all whom it may concern, well, that's kind of hard to make out in this digitization. It's got kind of these weird characters in it, et cetera. And these errors are kind of particularly important because, this patent finding platform searches only its own digitizations of the patents and not the actual patents themselves. And that can cause real problems for research. Now, in contrast, this platform has those digitizations right. So I wanted to show that to you, kind of highlight those for you in here. Now, just a quick aside, you've heard me say it now several times. I'm using that phrase, that word, whatever, digitization. I'm not using the word translation. And that's very specific for me in doing this presentation because the latter, translation, is really kind of more indicative of going kind of from one language to another, right? A translation. Whereas the former, digitization, really gets to the process of taking an original document and through like OCR, optical character recognition, or other electronic means, or maybe even kind of human effort, it makes it more readable or searchable. So you'll hear me say digitization throughout this entire presentation. I kind of hope that makes sense for you. Now, I don't want to beat a dead horse, but here's additional language from the body of that original patent. Again, this is from the body itself. You've got the quote, fertilizer distributor in here. You also have, quote, first mentioned, unquote. Now, again, check out the misdigitizations on this platform, right? You've got kind of some funky apostrophe in there. You've got a double I instead of FI when it comes to first mentioned, et cetera. And again, this platform's digitizations are correct. Fertilizer distributor, first mentioned. One final example, I promise. Here is the phrase, quote, like fertilizer, unquote, in the original patent, and the hyphenated word, quote, knife edge, unquote, from the original patent. And again, here's more misdigitizations. Now, pretty minor, but importantly, I want to note for you, this is actually from the USPTO's website. And again, this platform's digitizations are accurate. Now, I'm sure you're fascinated, right, about learning about the misdigitizations of this patent. You might be asking to yourself, okay, well, why is this guy, David Dillenschneider, why is he showing me information about the manure spreader? And why is he showing me this picture of Joseph Oppenheim? I mean, think about it, right? I could select from any number of patents to use in my examples throughout this presentation. Why the one about the manure spreader invented by this guy by the name of Joseph Oppenheim? Well, there's actually a reason. Because Joseph Oppenheim is my great-grandfather. Here's a picture of me, and obviously you can see the resemblance between my great-grandfather and me. And obviously, I'm kidding, right? But really the purpose of doing this was to really kind of get your attention at the outset of this presentation. I thought this example would be a good way to introduce the subject of this webinar. And you heard Leah mention it earlier, garbage in, garbage out, the need for comprehensive and clean data for patent research. Now, I'm going to do this in the context of ethics because, as you're going to hear in just a moment, the ethical guidelines of most states require a practitioner to kind of be up to speed on the latest technologies and being knowledgeable about how patent-related information is like handled, I guess you'd say, by the various patent-oriented repositories, platforms out there. That's really applicable in this kind of ethics context. Now, you heard me introduce myself a little bit earlier. My name is David Dillenschneider. You heard me mention client relations consultant for LexisNexis. I've actually been with LexisNexis now for about 20 years. Before that, I was actually a practicing litigator for a law firm in Columbus, Ohio. Now, before we get into the heart of the presentation, I just want to kind of set forth an agenda for you so you can kind of get a sense of how this is all going to flow for you. So first, I want to highlight basically that critically important ethical rule, which really guides the discussion today, because it emphasizes how important it is for today's practitioner to stay up to date on the latest technology. You're going to hear me talk about that a lot throughout this presentation. Second, I'm going to discuss the need for any patent-oriented repository of information or a platform out there that a practitioner like you guys are using, the need to have comprehensive data. Then I'll talk about accurate data. Now, this discussion is really going to focus on, the discussion of accurate data is really going to focus on the open web. And that's a place where some researchers actually look to information these days. Then I'll move into a discussion of kind of error-free or clean data, which in my view is a bit different from accurate data. And in fact, the manure spreader example I started this presentation with hopefully illustrated the difference between unclean data and clean data. Now, next on my agenda, or fifth on my agenda, is the discussion of disambiguated data. And basically, it's data that seems to be identical, but really isn't, and how a patent-oriented repository or platform, it should be able to differentiate between the two. Now, related but different to that is the next topic, harmonized data, which is basically the opposite of disambiguated data. Disambiguated data is kind of seemingly identical, but actually different. But harmonized data is seemingly different, but actually identical. And you'll get a sense of that as I get deeper into the discussion. Now, I'm using these phrases, right? Disambiguated data, harmonized data, clean data, et cetera. Don't get caught up on that language, the semantics, however you want to phrase it. Those are really just categories I'm using to organize this presentation. So you might personally think that one type of issue I discuss belongs into a different category than I put it in. That's fine. Remember, for purposes of this discussion, this presentation, these categories simply just make it easier to understand the discussion. Now, lastly, up there, last bullet, I'm going to touch briefly on the topic of artificial intelligence, certainly a lot top of mind for many of you, and really focus on the need for every practitioner to understand its possible benefits, certainly, but also its limitations. Again, think about that ethical guidelines. Now, wow, I mean, that sounds a lot, right? I got a bunch of bullets up there, but our time is going to fly by. I certainly hope by the end you have learned a little something about the need for comprehensive and clean data in your world of patent research. And certainly a benefit of that also is bagging one of those coveted ethics credits. I know it's getting into November. For some of you, the end of your credit year, I guess, compliance year is December 31st. So this is great for you if you haven't gotten your ethics credit already. Also want to kind of remind you that you are going to get a handout for this presentation. It's just going to be a handout. It's not going to be all the slides. There are a lot of slides in this presentation, but the handout is a nice summation of the key points of the discussion today. And I do have an eye on my clock. I'm going to make sure we get you guys out of here on time. Now, before we really get into the heart of this presentation, though, I got to also give you my disclaimer. You don't have to read it. Just understand this presentation is not legal advice. It really just consists of my thoughts on the need for any patent-oriented database, repository, whatever, or platform that you're going to use, whether you've been retained by as outside counsel, whether you work as an in-house attorney, the need to have comprehensive and clean data. Just my thoughts about that. So in short, I put this presentation together really to be kind of mostly just thought-provoking. That's it. I don't want to get an email from you guys 3 months from now saying, oh, you talked about this in your presentation, I relied on it, X, Y, and Z. As much as I almost hate to say it in today's environment, do your own research. All right, so let's get going here. Now you'll see up here on the slide a quote. I love this quote because it really reflects the need for comprehensive and clean data when doing patent research. Whether, again, you're the one doing the analysis yourself, or maybe you have a platform doing it for you. Of course, in either instance, you want the analysis to be accurate. But if the amount of data being relied upon is limited, or if the data being relied upon is wrong, you may have real problems. Now, the information contained in a patent application is obviously critical for patent examiners, right? If the information is wrong in the application, it can result in the application being rejected, or even a patent being issued for a product or the like that doesn't or maybe could not work. And as you can imagine, a whole host of issues, could follow that from that. Such as, not only have those possibilities of rejection or almost a misissuance of a patent, think about the other kind of problems out there. Like, for instance, reduced efficiency. And that's only if you recognize that the data that your analysis relied upon is incomplete or, you might say dirty. It means you've wasted time doing your analysis based on that bad information, and now you got to redo the analysis with better data, reduced efficiency. That's one of the consequences of the lack of comprehensive or clean data. But there's also, if you've got an incomplete data set or a poor data set quality, that could really result in bad or inaccurate analyses. Well, then you got the chance of one of more opportunities basically being missed. For instance, when a practitioner is doing portfolio benchmarking, that is kind of analyzing one company's IP against another company's IP, that practitioner needs to have a complete picture of those respective companies' IPs. Otherwise, the opportunity might be missed. The same goes for assessing innovation activity in a particular tech field. Finally, if your analysis relies upon incomplete data or poor quality data, well, if as a result of that, your analysis is deemed faulty, well, your reputation could take a hit, and it could possibly affect future work opportunities. And this really hits home with me because I understand how maintaining a good reputation is a real thing. In fact, a couple of years ago, I was doing a presentation at a law firm. I was doing this presentation in front of a group consisting of mostly associates, and I was discussing the inaccuracies of the results presented by a particular free research search engine, I guess you'd say, that oftentimes associates will use kind of as a shortcut when they're doing their legal research. Now, towards the end of my presentation, one of the few partners in the room, she interrupted me and asked to say something, which as a presenter is a very scary proposition, but I let her stand up. I let her speak her mind, I guess you'd say. And she stood up and she talked directly to the associates, and she told them that at that firm, the attorney should never use the search engine that I was talking about because of its potentially inaccurate results and the potentially resulting risk that such results presented to the firm and its reputation. So reputation is a real thing. You do bad work, it can affect your reputation. And this all leads to our guidepost for this presentation, when I promised you, the Rule of Professional Conduct 1.1. Now, Rule 1.1 is the competence rule. It's fairly simple. It's up there on the screen. Quote, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation, unquote. Now, you see on the slide, I've got the ABA's model rule, and that's because the vast majority of states, their rules of professional conduct or responsibility mirror those of the ABA's. Now, I suspect that after you're reading that language, you're saying to yourself, okay, well, what does that have to do with patent-related data, okay? Well, the language of Rule 1.1 is actually fleshed out in its commentaries. And of particular importance for today's practitioner is Commentary 8, which states that a practitioner must be aware of, quote, the benefits and risks associated with relevant technology, unquote. And I mean, Commentary 8 to Rule 1.1, it's still relatively new. It was formally adopted by the ABA just about 11 years ago in 2012. But since its approval, it's been adopted by 40 states, and I suspect that in the coming years, even more states are going to adopt it. And the requirements, as fleshed out in Commentary 8 to Rule 1.1, it's a real thing. Commentators have noted this. And I mean, hopefully that's one of the reasons that you're attending this webinar. I mean, to further that point, here's language from an article from the Oklahoma Bar Journal from just a few years ago. It really echoes this responsibility, right? You've got to understand the risks associated with the relevant use of technology to stay competent. And by the way, it's not just commentators saying this. Here's language from the State Bar of California itself addressing the evolving nature of the requirements under Rule 1.1. All right, so what does Commentary 8 mean for practical purposes, for you all, right? Well, think about the recent pandemic and think of all the video conferencing technology, Zoom, WebEx, etc., that we were using, and think about it in the context of communications and confidentiality. You got to stay up to speed on that tech to ensure that you're compliant with 1.1. And there's other kind of real, more concrete examples. For instance, this article discusses counsel's responsibility to protect client confidences in the context of cyber attacks. And this judge admonished counsel for not being familiar with metadata, specifically citing 1.1 and an interpretation set forth in an advisory opinion. In particular, look at the opening language of this footnote 6, quote, "We do not mean to excuse counsel's lack of familiarity with metadata," unquote. Another recent kind of real-life example is from the lawsuit involving the media personality Alex Jones. So as you may have heard, in a couple summers ago, summer 2022, his attorney inadvertently disclosed the entire contents of Jones' cell phone to opposing counsel, who then used the information he obtained to claim that Jones had lied on the stand when testifying about a certain matter. Well, there was an article concerning that incident, and some of the attorneys, the attorneys who wrote that article wrote that most news sources believe that Jones's lawyer made a mistake of mind-boggling proportions, right? Absolutely, that makes sense. But later in that same article, those same authors posited that Jones's attorney's mistake was, quote, "a clear Rule 1.1 violation," unquote. And obviously that's based on Commentary 8. Interestingly, the same attorney involved in that prior example was subsequently found to have violated 1.1 for failing to keep highly sensitive records that had been the subject of a protective order confidential. So he got kind of nailed twice, although in this case, the court didn't impose any sanctions. Now, those are just a couple examples. There's lots of other ones out there. In fact, according to a recent law review article that I read, courts have imposed duties of technological competence in many areas. And it's kind of constantly expanding. And it actually now seems to include the use of artificial intelligence. So, in fact, I suspect a lot of you have heard by now that this past summer, a judge imposed sanctions upon two attorneys who relied upon ChatGPT to write a response to a motion to dismiss because ChatGPT included citations to opinions that didn't exist, right? And according to a commentary I read about that incident, the problem wasn't that the attorneys used ChatGPT. Rather, it was that those attorneys didn't understand it. I mean, in my opinion, knowing the quantity and quality of data that informs a platform or a site that a practitioner uses for patent research falls squarely within the requirements of Commentary 8 to Rule 1.1. And a final note about this, right? You can't stick your head in the sand. You can't avoid the latest technology and later claim ignorance. "Oh, Judge, I didn't know." And this opinion notes, quote, "deliberate ignorance of technology is inexcusable," unquote. Now, a little bit of a caveat to that. Although deliberate ignorance is not acceptable, you don't have to become a technologist. I mean, we got so much going on our plates already. The key point, I think, is just to become somewhat educated, learn about what you don't know, and then if necessary, retain experts to kind of assist you when it comes to kind of the nitty-gritty out there. And in fact, by participating in this webinar, you're not sticking your head in the sand, right? You're going to become at least a little bit familiar with some of the benefits and risks associated with the repositories and platforms out there that contain or utilize patent-related information. So that's where we are so far, or I guess we could say as far as my research has taken me so far. All right, so let's move along, right? What should you be aware of when it comes to thinking about comprehensiveness and clean data for patent research? Well, first, more data is better. To put that simply, 1,000 data points is better than 10. Second, the data's got to be accurate as well as clean. And I'll explain the difference again between accurate data and clean data here in a few moments. Fourth, because even clean data can be confusing or inaccurate, there's a need for disambiguation. And then finally, in the same vein, the data has to be harmonized to kind of get the most out of it. Now, as promised, here's your first code for CLE purposes. Now remember, you're going to need this code to get your CLE credit, so please write it down. You'll see it up here on the screen. Grab a screenshot, write it down, whatever. I'm also going to say it verbally twice, and note that the letters are lowercase. So I'll say it twice here, M-R-D-P-R. And I'll say that again. M as in mouse, R as in radar, D as in donut, P as in panda, R as in radar. That is your first code. At the very end of this presentation, I will give you your second code, all right? So make sure you got this first one. I'll give you the second one at the end of the presentation. So let's move forward with the first thing to consider. More data is better. Now, the idea of more data is better, it didn't originate with me. I actually stole it from an article that I read recently. But the author actually phrased it a bit differently, citing the need for a huge data set, unquote. That makes sense because, as I mentioned early on in this presentation, the more information that can be offered for analysis, whether it's done by you manually or by the platform that you're using, the more informed that analysis will be. I mean, think of your work as a puzzle. You want as many pieces as possible so that you can see the entire picture. Sometimes even one missing piece can be devastating to your ultimate conclusion. Now, in my mind, a huge data set is comprised of two components. You see them up here on the screen: depth of coverage and breadth of coverage. Now, when it comes to depth, think of time, not only how recent the data is, but also how far back the data set goes, as well as, I guess, how complete the data set is over time. Breadth encompasses scope, that is the set of sources of patent-related data that are available from the repository that you're looking to, or maybe that get tapped by the platform that you're using. So considering depth, take a look at one platform's list of results for a particular patent examiner up here on the screen. And specifically, you're going to see granted patents and abandoned applications kind of sorted chronologically, meaning that the newest granted patents or abandoned applications are displayed there at the top. So here are the 10 most recently granted patents, at least as of mid-September when I started putting this presentation together. Now, I'm going to overlay this list with a list of results for that same patent examiner, but from a different platform. And I pulled this list at the same time. And notice, by the way, that this list only includes granted patents because there's a separate tab up there at the top for abandoned applications. More to the point here. Both platforms list 084. That's what I'll call that. They both have 818. They've got 149. They've got 241, 955, 840. But noticeably, whereas the second platform lists granted patents 120, 457, 872, and 547, the first doesn't yet list them, or didn't list them in September. So this suggests that the first platform has a smaller or reduced depth of coverage. Now, you might be saying to yourself, well, David, that's interesting, but what about 095 over there on the left-hand side? I mean, the first platform does list it there, but so does the second. It's just on the second page of the list. I couldn't get it all there on that first screen capture, I guess you'd say. And the second platform also has 297, 797, and 903. Again, all on the second page there. That's kind of a reflection overall of depth of coverage between two platforms, a comparison. The key point is know as much as you can about the resource that you are using for your research. For instance, here's some commentary regarding one repository that has patent-related data. And note how it states that there may be holes in the database and how recent patents might be missing. Again, think back to that puzzle piece. And when it comes to depth, consider the extent of retrieval. For example, here again is part of that original patent I started this presentation with. And you'll see, for instance, that it references paddles, an integral part of the manure spreader design. Now, by the way, I'm going to highlight that because I think it's interesting because according to Wikipedia, my great-grandfather decided to include paddles in the design of the manure spreader after watching children play a game called Tomball, which involved a paddle-shaped board. Fascinating stuff. But anyway, the original patent, it also includes the phrase, you'll see down there at the bottom left, whereby a knife edge, unquote. So at this platform, a practitioner can search for that term and that phrase, but the patent can't be found. But the platform does have that patent. It just isn't searchable. It even actually can be retrieved. It says over there on the right, download the PDF. Now, depth of coverage is important not only for mere retrieval, but also for purposes of analytics. For instance, a patent examiner's behavior may change and actually usually does change over time. So for example, here's one platform's analysis of examiner Eric Alvarez Zamora from 2018. You'll see an allowance rate of over 86% there on the left-hand side, an examiner time allocation, or what's called an ETA of 13, which is shown in red, suggesting basically a long slog to grant. Now, if you're interested, ETA has a numerator of total office actions and a denominator of total allowances. The nitty-gritty of it isn't really critical to this presentation, but I just want to display that for you because you can compare that number 13 to a more recent 2023 analysis provided by that same platform for examiner Zamora. And this 2023 analysis, I mean, it shows the examiner still has a very high allowance rate, over 85%. But now, since 2018, and now in 2023, he has a green or a more favorable ETA, shorter time for decision, right? Instead of the red ETA of 13 from 2018. So I hope that makes sense. Now, when it comes to analytics, there's another kind of weird thing to consider when it comes to depth of the data set being searched. All right, so here's one platform's analysis for patent examiner. I'm not even going to try the name. It's worse than Dylan Schneider. We're just going to say Q. And it seems fairly normal, but there's one particular thing of note. It seems that examiner Q left that role as patent examiner for 4 or so years. You'll see that kind of highlighted down there at the bottom. Now, I got no idea why he left that role, or he or she left that role, but this platform captures both the examiner's first stint as well as the second one. And importantly, it captures 658 total applications the examiner considered over those 2 stints. In contrast, here's another platform. It lists only 70 cases or applications, I guess, suggesting possibly that it didn't maintain the data for this examiner when he or she left that role for about 4 years. Now, obviously, it's very rare for an examiner to leave the USPT role as an examiner and then later return. But what if you had that situation and that examiner was assigned your application immediately upon his or her return? Wouldn't you want some data, even if it's a few years old, to help inform your decisions? Now, there's also that breadth of coverage. And for that, basically, I just think about countries. It's not a big deal, but some sites claim to have an extensive collection of patents. The point is, don't be fooled. Remember to consider not only what those sites actually have in their collection, but also whether what they have is searchable. For example, via translations or digitizations and the like, all right? Think of that breadth. Now, the second thing to consider is whatever data set is being used, it's got to be accurate. Now, this really pertains to the trend of practitioners to cite various websites in their patent applications. I mean, check out this language from the Wikipedia page regarding patent research down there at the bottom. Quote, "The internet is a popular source of technical information," unquote. And that trend really isn't helped by suggestions at various sites out there to, quote, "search Google," unquote. All right, so many years ago, when my family was planning a vacation, I asked for their suggestions as to where we should go. Now, my son found this website and suggested that we head to the Pacific Northwest and search for the Pacific Northwest tree octopus, because he found the site which talked about this animal. But my daughter wanted to visit the Great Lakes for some whale watching. And so she showed me the website, and when I checked it out, I was reassured because it actually self-verified. It said, yes, it is true. But my wife thought the Golden Gate Tunnel looked more interesting, particularly as she thought that the kids and I could go to the donut court while she took a break at the day spot in the tunnel. Now, my goal here was really kind of make you guys laugh, right? You guys know these are all parody websites, kind of reflecting the fact that not everything found on the open web is true. And obviously the falsity of these websites is pretty evident, okay? But not everything is so evident, right? I mean, what about me? I mean, a few years ago, I came across this site which said that I was a director at Integrated Research. I found that interesting because I've never worked for that company. I got no idea what they do. And I've never worked for Yahoo, even though there was a website that said I was an account manager for that company. And this site said that I was an expert witness. I'm not. Now, I understand these are just kind of random sites out there. But what about sites that practitioners really trust and have regularly cited in patent applications? For instance, here's a patent application that was just filed about a year ago. And in that application, there's a citation to a Wikipedia entry, a neighbor joining tree, it looks like. And here's that entry from Wikipedia, right? Or here's another recent example, which says in part, quote, "according to Wikipedia," unquote. All right, here's the problem. Take a look at this social media post in which the poster notes that he edited Wikipedia on the fly to show that he was, quote, "family," unquote, in order to get into the VIP area at a band's concert. And there's the name of the poster right there at the top, Adam Boyd. And here's the Wikipedia page for the band, which, at least at the time I grabbed the screenshot, shows that poster, Adam Boyd, is a cousin of the main vocalist of the band, even though he isn't. That's the edit that he made. In short, anyone can edit Wikipedia for any purposes. Now, I'm not going to get into a discussion of the manual of patent examining procedure, the use of the Wayback Machine, social media, stuff like that. Rather, my point is that you got to be careful about what you find out there on the open web. I'm not saying don't use it, just be careful. In fact, many years ago, the Patent Office recognized this and barred its examiners from using Wikipedia when evaluating patent applications. Nonetheless, in 2010, it was noted citations to Wikipedia were still increasing. And even more recently, according to a chart I found through a recent Google search, and remember, everything you find on Google is true, that trend seems to be increasing. Just remember, Wikipedia itself makes no claim as to the validity of its information, its entries. So when you conduct your search online, whether through the open web, through a specific website like Wikipedia, you might think you're getting this, when in reality, you're getting this, okay? So the third thing to consider is whatever data set is being used, it's got to be clean. Clean data is fundamental to data analysis because of the concept of this whole presentation, right? Garbage in, garbage out. So I actually recently attended a webinar during which Dr. Christopher Wallach, he's the head of strategic IP management for Henkel Adhesive Technologies. He gave his thoughts about the importance of good data when conducting patent research. And you see a quote up there on the screen. And what really struck me was his comment about the difference between bad input data and good input data. Now, his comment was made in the context of visualizations, but it obviously relates to analyses generally. And in particular, I found this succinct quote that you see on the screen very informative. Specifically, quote, "You need a very good and clean input data set for having a good assessment, unquote. Very good and clean input data really sums up the idea of today's presentation. Now, I started this presentation with my great-grandfather's patent for the manure spreader and some of the misdigitizations of it that I found at various sites. And believe it or not, misdigitizations occur far more often than you probably realize. So I'm going to continue on with that opening example, but now I'm going to show the consequences of such misdigitizations. Okay, so just a few moments ago, I showed you this slide with part of the original patent with the words paddles and the phrase whereby a knife edge, right? So I showed you this to you a couple minutes ago. Now, at this site, the word paddles is correctly spelled. That's pretty easy. But a hyphen is erroneously inserted between the words a and knife edge. Or another site, the word paddles is also correctly spelled, but the words a and knife edge are, I guess you'd say, kind of merged. The consequences of such kind of seemingly unimportant misdigitizations can be significant. For instance, at this site, a search of that word and that phrase as used in the original patent that I showed you, it yields 0 results. The same holds for a similar search at another patent data search site. Yet we know that the patent includes that word and phrase, and here's a third example. But check out this site. The identical search of that word and phrase finds the manure spreader patent from 1900. Even more egregious is this example. Again, this is some text from the original patent, which starts with the word shown and ends with the word distributing mechanism. You see those underlined there on the screen. And look at all that text in between there, right? Now, this site's digitization of the patent seems to have the same text, right? In fact, the relevant portion starts with the word shown, and it ends with a slightly messed up phrase, distributing mechanism. But in fact, this site's digitization completely omits language from the original patent. Here's the portion of the original patent that is missed by the previous site's digitization. It's not there at all. And obviously, the consequences of a digitization that fails to include language from the original patent is that a word or phrase from the original patent that is searched for at the site where the language has been omitted fails to find the original patent. Now, another example, at least in my mind, of cleaning work is assignment monitoring. Now, some might consider assignment monitoring to be harmonization. I'll address that in a few moments, but I've included it here under the topic of cleaning. So look at this patent from 2008. In fact, there's my name listed as one of the inventors on this patent. And there's the number. But importantly, note that it was assigned to LexisNexis. Now look at that now look at the patent as it's displayed on this other platform. Still has my name listed as one of the inventors, still has the same number, but the owner on this version is different. It's now RELX. In fact, the name LexisNexis doesn't appear anywhere on the patent is digitized by this platform. And that's because RELX now owns the patent. This is important because RELX didn't exist until 2015, when Reed Elsevier, the parent company of LexisNexis, changed its name. So this platform kind of cleaned up that data so that when a practitioner searches for patents owned by RELX, it finds this patent, even though that name, RELX, is not on the original patent. I hope that makes sense. In fact, if you go out there and you use this platform and you try to utilize the owner field to find LexisNexis, the platform actually will prompt you to use RELX because LexisNexis is a sub of RELX. And the result is that my patent is very easily found on that platform. Now, it can be found via other platforms as well due to kind of cleaning work that is done by them. And again, here's another platform that got it right. But I want to give you another example. A couple of years ago, October 2021, Mark Zuckerberg announced that Facebook was being renamed Meta, with its subsidiaries being Facebook, Instagram, etc. So a while back, I searched Meta on the platform, and I retrieved a possible number of hits, including one from Meta platforms, which shows 6,012 patent families. I also, at the same time, searched Facebook on the same platform. And you can see that one of the hits I retrieved was for Meta platforms, and it shows Facebook as a subsidiary name. Importantly, it shows 6,012 patent families, and by the way, just so you know, same holds for Instagram as well, because I did the same search on Instagram, 6,012 patent families. All right, one more example. Check out this patent. Note the name of the applicant here, Intellectual Business Machines Corporation. Now, that should set your radar off, right? Obviously, it's wrong. It should be International Business Machines, IBM. But it's wrong on the original patent. And there's a patent number up there at the top. We're going to call this one 8002. So you want a platform that will correct that for you. That is, enable you to find that patent even if the applicant name or owner number or whatever was misspelled or messed up in the original patent. So in this case, you type in the name Intellectual Business Machines, and it knows that you're looking for IBM. Now note that it's not actually changing the text of the original patent. The platform is just making it easier to find. Because if the platform doesn't do that, that patent will never be found via a search of IBM. And you can find that patent by simply searching for IBM. And note that I added the 8002 patent number to make this example easier, just because IBM has bazillion patents. But you can find that patent under IBM, even though it was whatever, Intellectual Business Machines. You want a platform that's going to do that for you. All right, so far I've given you 3 of the 5 things I think should be considered when evaluating data that practitioners, you all, might look to when you're conducting your patent research. Those things really relate to the data itself. The final 2 things in this list relate more to the platforms that utilize patent-related data to create analyses for you. So what about disambiguation, which, by the way, it's a real word. I checked it out. It's the 4th thing to consider when you're doing your evaluation of a data set of patents or a patent platform. I'm going to jump outside the realm of patents for a moment because I want to introduce you to a pitcher in baseball by the name of Brady Fiegel. I'd like you to also meet another minor league pitcher also named Brady Fiegel. They're both pitchers. They look alike. They got the exact same height. They both got red hair. They got beards. They wear these kind of glasses. They've actually both had Tommy John elbow surgery done by the exact same doctor. Very, very similar situation here. And of course, you got the identical name. But a DNA test proved that they're not related to each other at all. But if you were an opposing minor league manager and your team was facing pitcher Brady Fiegel, you certainly want to be sure that you have the relevant statistics for the right Brady Fiegel. Jumping back into the realm of patents, look at this office action summary. It notes that the examiner is, Daniel Miller. There are actually 4 patent examiners with that name, though with different middle names. Now, obviously, one could surmise by the art unit designation on the office action summary on the list of patent examiners that the Daniel Miller in question here is Daniel A. Miller. But you get my drift. And most of the patent examiner platforms I've checked out have been able to do this type of disambiguation, but still be aware of this potential problem. The last thing to consider is harmonization. Now, again, some might consider some of the examples I provided in my discussion of cleaning as actually harmonization. That's fine, whatever. I just want to provide you with some examples of what I consider to be harmonization. So consider this application. It has patent examiner Paul Nagayan Ba assigned to it. Now, just as an aside, this guy is no longer active. But here's an office action summary for that same application. In fact, you can see the same application numbers right there. Now, check out the examiner's name, though, on the summary. It's still Mr. Nagayan Ba, but now there's a hyphen between Nagayan and Ba. Maybe not a big deal, but a good analytics platform should be able to recognize that those 2 names are one and the same. In fact, this platform recognizes variants of that name in the various patent documents, calls them out, and ensures that a user can get the same analysis regardless of which variant the user selects. So if one selects the statistics link on the right, he or she's going to get the same set of results for Paul Nagayan Ba. Got the primary art unit number of 2176 there. But note that this is actually a good opportunity to look back as well. Because remember, Paul Nagayan Ba is no longer an active patent examiner. So accordingly, some platforms no longer offer information about him. Here's one example. And here's another example. And note that examiner Nagayan there on the right-hand side next to the X is not Paul Nagayan Ba. Now, that may not be a big deal for you, but for some practitioners, that data could be important because remember this patent examiner, examiner Q, I called him, who left but later came back? Having his or her data could be critical. Or consider this office action summary, which notes that the patent examiner is Lindsay Schneider. But a search of current patent examiners indicates that, hey, no examiner exists. So you might think, okay, well, I can't find any analytics regarding that particular examiner. But look at what this platform does. A search of Schneider reveals a list of possible results, including one for Lindsay Schneider, which notes that she is also known as Lindsay Summit. And if you look at the analytics for that patent examiner, Lindsay Summit, it lets you see that Ms. Summit is also Ms. Schneider. So apparently Ms. Schneider maybe is the maiden name of Ms. Summit or something like that. This platform picked up that connection. But harmonization work goes beyond just tracking name variations of patent examiners. It includes stuff like ensuring patent sub-relationships are accurate, tracking corporate name changes, assigning ultimate owner when there's a merger acquisition, recognizing, disambiguating similar entity names, stuff like that. For instance, take a look at this example. International Business Machines Corporation, IBM. It has patents filed under approximately 20 variations of the spelling and usage of its name, its acronym. So if you type in International Business Machines as an owner into this platform, you get 44,619 results. But you get the same number of results if you type in IBM or IBM with the periods between the letters, or even International Business Corporation. You probably want a platform that will perform such harmonization, as sometimes there can be inconsistencies in patent applications, and most platforms will pick that up. But what if you do something really wacky and make a slight typo like this one, right? IBM with spaces between the letters, no periods. Again, you're going to see 44,619 results from this platform. But some platforms apparently don't harmonize that type of typo, as you can see up here on the screen. All right, so up until this point, I've been talking about data sets that are used by practitioners and the analytical platforms that you might use. What about AI, particularly generative AI, which creates output based on data that it's been trained on? I seem to be kind of seeing it everywhere. I'm sure you guys are too. It's starting to make its way into the world of research, particularly the research of patent practitioners. Now, I'm not going to do a half-hour discussion of generative AI, but I do want to focus on what I just mentioned. That is, generative AI is trained on data. And accordingly, there's that risk of garbage in, garbage out, or with respect to the latter, what they're calling hallucinations. In order to be compliant with Rule 1.1, when using generative AI, practitioners must be aware of this risk of hallucination. Hallucinations are a real risk because of the quality of some of the data sets that are used to train generative AI platforms, like ChatGPT. As you can see here on screen, one of the data sets used for training is Wikipedia, which I think maybe it's ironic. It's noted by Wikipedia itself. It's used to train ChatGPT. Well, so we're very close to the top of the hour. We're going to get almost to the end of this discussion, but if you're going to indulge me for just a second, I'm going to go back to the example I started this presentation with. Specifically, go back to that manure spreader. So here's a Wikipedia entry for a guy by the name of Henry Sink up there at the top. And you'll see here that he is the son-in-law, or was the son-in-law, of my great-grandfather, Joseph Oppenheim. And not only that, this Wikipedia entry also indicates that he was a co-inventor of the manure spreader with my great-grandfather. But wait a second. I mentioned earlier that my great-grandfather was the inventor of the manure spreader. I didn't say co-inventor. So what's up with this Wikipedia page? Well, you'll see right there that this is an old version of Sink's Wikipedia page. I grabbed it as of the edit date, June 29th, 2008. So here's the Wikipedia page for Joseph Oppenheim that I showed you earlier. I mean, it says that he, quote, invented the modern widespread manure spreader, unquote. And it gets even more specific, quote, only he is honored for that invention, unquote. So what happened? I mean, here's the current Wikipedia page for Henry Sink. It's the current page, and it now says only that Sink worked to help develop the manure spreader. It actually specifically references, quote, Oppenheim's 1900 invention, unquote. So the inaccuracy on Sync's old Wikipedia page entry has been basically corrected, right? In fact, check out the history of Sync's Wikipedia entry. The reference to Sync being the inventor of the manure spreader was removed by an editor because, quote, this statement is not documented, unquote. And it further notes that the USPTO shows that Oppenheim was the recipient of the patent for the manure spreader. Oh, and by the way, who is the editor who made that change? That was my dad, John Joseph Dillenschneider, who made the edit on February 23, 2011. The point is, had my dad not diligently edited the Wikipedia entry of Henry Sync, it might still exist with its false information, feeding a generative AI platform ultimately to generate an hallucination. So it's a good thing that Sync's entry got corrected so that ChatGPT can get it right for its users. One more thing. Here's an actual ChatGPT search I ran about a month ago as I was preparing for this presentation. Now, please note I was using the free version of ChatGPT, which my son says is not as sophisticated as the paid-for version, whatever. But look at my query up there at the top. Who invented the manure spreader? And there below it is the result that was generated. And it correctly notes that my great-grandfather invented the manure spreader. But look at the rest of the result. Note that it states that my great-grandfather received his patent for the manure spreader in 1875. But remember that the patent for the manure spreader was granted in 1900. And that's actually noted, as I showed you, on the Wikipedia page for Henry Sync. But it gets even weirder because Joseph Oppenheim was born in 1859, meaning that if the patent for the manure spreader was granted in 1875, my great-grandfather was 16 years old when he received it. And one more thing about that, 1875 is not the, quote, early 19th century, unquote. Now, I don't know where the information came from, so I can't really speak to the garbage in, but this is definitely a garbage out situation, a hallucination. So one other thing to consider about this, by the way, the data being used to train generative AI platforms becomes dated immediately. It becomes dated possibly tomorrow. So if the data isn't being tapped in a kind of a contemporaneous real-time manner, it could be old data that is no longer accurate. So kind of think about that as well. Look, just as you're expected to know about the ins and outs of other technologies, you got to be knowledgeable about AI, including how generative AI platforms may be trained on bad or old data. And note that besides the likely applicability of this ethics rule I've been talking about, 1.1 and its commentary 8, states are also looking to even more in depth at the ethics issues related to AI. So just kind of be aware of that, be on the lookout for those developments in the near future. All right, so we're now at the end of the presentation. Don't leave yet, all right? Because first of all, I'm going to take a look and see if there were kind of any questions coming in. There was actually one came in on a private chat here. It said, kind of funny, it said, this is a lot of information. How do I know which place is best to go for patent research? I think the way to think about that is think of your patent research. Evaluate and compare. Yes, this is a lot of information, but I had to go out there, evaluate sites, compare them, that sort of thing. From my experience, the lessons that I took away were simply, be a bit wary of free sites, kind of you get what you pay for situation, but also understand the ins and outs of all the sites. If you can do like a free trial or something like that, it can certainly help out when it comes to evaluating a platform. Don't necessarily take their marketing language at face value. Do your own analysis. All right, a couple other things here. I want to make sure I got to that question here. Second thing is I got to give you that code. So I'm going to do that here in just a moment. But right after the code, we're going to close out this webinar. And I just want to remind you to please, if you could, make sure that you complete the survey. It's a very short survey, but it's going to help us to really ensure that what we provide for you during these webinars meet your needs. So please be sure to do that for us. It really is helpful. But the last thing I'm going to do here is I promise got to give you the second code. So here we go. Again, you need this second code just like the first code. Write it down, take a screenshot, whatever. All the letters are lowercase, although there's some numbers in here as well. A little confusing on this code, and it's not my fault. that first letter is lowercase l. So I'm going to speak the code twice. You have L, H, you've got the number 9, and then U. And I'll do that again for you. L as in llama, H as in house, again, the number 9, and then U for umbrella. Make sure you have this second code along with the first code to help you get your CLE credit for attending this presentation. But I'm looking at my clock. I'm right at the top of the hour. So thank you again for joining us today. I hope you learned a little bit about the tech out there when it comes to patent research, and also learned about it in the context of the ethics responsibility, knowing as much as you can, not as much as you can, but what you can about technology. It's applicable not only in patent research, but in other types of research as well. Very, very important for you to understand that. With that being said, I'm going to turn it back over to Leah to close us out, and we're all done. Thank you very much.
Thank you. Have a great day, everyone. Thank you for joining us.